Hello and welcome back to Ganga Education. On this platform, you will find quality lectures relating to the field of law, competitive examination in legal domain, important legal facts and legal history, all explained in clear and structured manner.
And in today's video, we are going to discuss Bharatiya Sakshya Adhiniyam 2023 from section 121 to section 123, that is estoppel and presumption.
Hello and welcome. Today we're diving into section 121 of the Bharatiya Sakshya Adhiniyam 2023, which deals with the doctrine of estoppel. Now, this section is incredibly important for both the judiciary and APO exams, so let's get right into it and understand its concepts in detail.
In this explainer, we'll first get a grip on what estoppel actually is. Then, we're going to break down its essential ingredients. After that, we'll see how it works in the real world with practical examples and case law, discuss some key legal points, and finally, we'll wrap up with a sharp focus on how to prepare this topic for your exams.
So, let's kick things off with our very first section. What exactly is estoppel? You see, this is a fundamental rule of law, and its foundations are built on the principles of equity, justice, and good conscience.
To put it in really simple terms, it just means this: you cannot go back on your word if someone has acted on it. This principle is all about ensuring fairness and honesty in legal dealings. So the main mantra here is to be consistent with your own statements. Okay, let's look at the language of the BEAR Act itself. Section 121 says that when a person, through their declaration, act, or omission, intentionally makes another person believe something is true, and that other person then acts on that belief, well, the first person can't later deny the truth of that thing. Here, declaration means a statement, act means an action, and omission means failing to do something you should have.
Let's move on and break down the essential ingredients of Section 121. You know, before a court applies the rule of estoppel in any case, it carefully checks for these specific elements.
So to prove estoppel, there are 5 essential ingredients that must be present. First, representation. Second, intention. Third, reliance. Fourth, a change of position. And fifth, the matter must be between the same parties. Let's take a closer look at each one of these.
Let's start with the first 2 ingredients. First up is representation. This means there has to be a statement or some conduct that's related to a fact, not a point of law. For instance, saying, "This land belongs to me," is a representation of fact. The second ingredient is intention. The person who made the representation must have clearly intended for the other person to believe it and act on it.
Now for the third and fourth ingredients. Third, we have reliance. It's absolutely necessary that the other person actually believed the representation and did something based on that belief. And fourth, change of position. Because of that action, the person must have suffered some kind of loss, or their position must have been altered in some way. Estoppel won't apply without some tangible consequence.
So far, we've covered the theory. Now let's see how this doctrine actually works in real-world scenarios and inside the courtroom. The illustration given in the Bharatiya Sakshya Adhiniyam itself is the perfect example. Let's say A falsely convinces B that a piece of land is his, and B goes ahead and buys it. Later on, A actually acquires the legal title to that same land. Now, if A tries to cancel the sale, the court will stop him. Why? Because A cannot go back on his own earlier statement. He is estopped. In this scenario, you can clearly see all the ingredients at play: representation, intention, reliance, and a change of position.
The foundational case that really established the modern principle of estoppel is Pickard versus Sears. This is an English case, which clearly laid down that a person cannot deny their own statement if another person has relied on it and suffered a loss as a result.
In the Indian context, the Supreme Court has also upheld this doctrine many times. In the case of Motilal Padampat Sugar Mills versus the state of UP, the court recognized promissory estoppel even against the government. Similarly, in Union of India versus Anglo-Afghan agencies, the court held that the government is also bound by its representations. For your mains exams, especially for questions on administrative law, these cases are incredibly important.
All right, let's now discuss a few more crucial legal points related to estoppel, the kind of things that are frequently asked in exams.
The legal maxim behind the doctrine of estoppel is allegans contraria non est audiendus. It has a very simple meaning. A person who is alleging contradictory facts should not be heard. This maxim is really the jurisprudential root of the entire doctrine.
Now, this is an absolutely crucial point. Estoppel is a rule of evidence. It is not a cause of action. It's famously described as a shield, not a sword.
What this means is that you can use it as a defense, but you can't file a new case based solely on estoppel. It doesn't create new rights, it simply stops someone from denying existing fact.
Before the new laws came into force, this provision for estoppel was found in Section 115 of the Indian Evidence Act of 1872. Now, under the Bharatiya Sakshya Adhiniyam 2023, it has been placed in Section 121. The substance of the provision is the same, only the section number has changed.
And now we come to the most important part of this topic, what you really need to remember for your exams. For the prelims, you can expect direct questions on the section number, that's Section 121, or on its core concept. For the mains, you should be prepared for a problem-based question or to write a short note on the Doctrine of Estoppel. And remember, always mention practical examples and case laws in your answers.
So, for a quick revision, just remember these three things. First, the section number, Section 121 of the BSA 2023. Second, its core concept. You cannot go back on your word. And third, its key principle. It is a shield, not a sword. The importance of this for your exams is, without a doubt, high.
Before we end this explainer, I'll leave you with a question to think about. How does the doctrine of estoppel strike a balance between the need for legal certainty and an individual's freedom to change their position? It's definitely something worth pondering. For more legal content focused on judiciary, APO, and other law exams, please stay connected with Ganga Education.
This section deals with the estoppel of a tenant and their licensee. And you know what? For your judiciary and APO exams, this one's super important. So let's get started. All right, let's kick things off with a very practical question. Imagine this. Can a tenant, a kirayadar, just refuse to pay rent by claiming, hey, you're not the real owner of this property? It's a really common legal problem, right? And the answer to that, well, it's right here in Section 116. So here's a quick roadmap of what we'll cover in this explainer. We'll start with the core rule of Section 116, then we'll break down exactly what tenant and licensee estoppel means. After that, we'll look at some landmark cases and legal principles, discuss the exceptions to the rule, and finally, wrap up with some exam-focused tips and a quick revision. All right, first up, let's break down the core rule of Section 116 and really understand what it's all about. So Section 116 of the Indian Evidence Act of 1872 is basically a specific application of the bigger doctrine of estoppel. It's a rule that's been tailor-made for landlord-tenant and licensor-licensee relationships. And at its heart, it's all based on the principles of equity and good faith. Okay, let's break down what that legalese really means. In simple terms, if you, as a tenant, enter a property under a landlord, you're not allowed to turn around during that tenancy and deny that the landlord has a valid title. The bottom line is this. You can't challenge the very authority that gave you possession in the first place. It's really that straightforward. So what's this word estoppel all about? Well, think of it as a legal principle rooted in fairness and good faith. It basically stops a person from arguing something that completely contradicts what they've already said or agreed to. It's like a legal you can't take it back rule. It's there to prevent people from flip-flopping to gain an unfair advantage. Okay, now Section 116 really breaks down into two main parts: estoppel for tenants and estoppel for licensees. Let's dig into both of these in more detail. To really get a grip on this section, we've got to understand the keywords. First, a tenant is pretty straightforward. That's the person renting the property. Now, a licensee is different. They only get permission to use the property, not possession. Think of it this way. A tenant has a key. A licensee is just allowed in. Landlord's title refers to the landlord's legal right of ownership right at the beginning of the tenancy. And similarly, licensor's possession means the licensor had the right to possess the property when they gave out the license. So when exactly does this rule of estoppel apply? Well, you need three essential ingredients to be present. Think of it like a checklist. First, there must be a valid landlord-tenant or licensor-licensee relationship. Second, the tenant or licensee must have taken possession under the authority of that landlord or licensor. And third, they later try to deny that very same authority. If you can tick all three of these boxes, then the rule of estoppel comes into play. Let's make this crystal clear with a simple example. Let's say A rents a shop from B. Everything's fine for a few months, but then A suddenly stops paying rent. When B asks why, A says, well, I found out you're not even the real owner. This is a classic case where Section 116 steps in. The law will prevent A from making that claim. A is stopped from denying B's title because A entered the shop based on B's authority in the first place. Okay, moving on. Let's now look at some landmark judgments that have really shaped how Section 116 is applied in court. A really foundational case you absolutely need to know on this topic is Sri Ram Pasrika versus Jagannath. This judgment was instrumental in defining the scope of tenant estoppel. So, the main question in this case was simple. Can a tenant question the landlord's title while the tenancy is still active? The Supreme Court gave a resounding no. The court held that all the landlord needs to do is prove that the landlord-tenant relationship exists. They don't have to prove their absolute ownership to the tenant, and this ruling perfectly captures the essence of Section 116. You know, there's a great legal maxim that perfectly sums up this entire principle. Nemo postes contra factum suum venire. It simply means no one can go against his own act. What you've accepted, you can't later deny. That is the very soul of estoppel. But here's a crucial point. This rule is an absolute. Like most rules in law, there are some important exceptions. So let's take a look at when the rule of estoppel doesn't apply. So there are specific situations where a tenant can actually challenge the landlord's title. First, if the landlord's title has expired after the tenancy started. Second, if the tenant gets evicted by someone with a superior title, like the actual true owner. Third, if the whole tenancy agreement was based on fraud or misrepresentation by the landlord. And finally, if the title has been transferred, for example, if the property was sold to someone else. Now, make a note of these, because these exceptions are extremely important for problem-based questions in your mains exam. And here's the most important takeaway about this rule. The estoppel under Section 116 freezes the situation in time. It only applies to the title that the landlord had at the beginning of the tenancy. It's like taking a snapshot. It doesn't apply to any changes that happen to the title later on. Please remember this point. It's absolutely crucial. Okay, let's pull everything we've discussed together now and focus on how you should prepare this topic for your exams. From a legal standpoint, it's very important to remember that Section 116 is a rule of evidence. It acts as a shield for the landlord, not a sword. What does that mean? It means this section doesn't create new rights for the landlord. It simply stops the tenant from making a particular argument. It's a defensive tool, a procedural bar. Now, a quick but very important update regarding the new laws. This principle was in Section 116 of the old Indian Evidence Act 1872. In the new Bharatiya Sakshya Adhiniyam of 2023, the same core legal principle has been retained in the corresponding provision. So, for your upcoming exams, this concept is just as relevant and important as it has always been. All right, here is a specific tip for your judiciary and APO exams. In the prelims, you can expect direct section number-based questions, but for the mains, you're more likely to see problem-based questions, focusing especially on those exceptions we discussed. So be prepared for both. All right, time for a super quick revision. If you remember nothing else, remember these three things. First, the section, Section 116 of the Indian Evidence Act. Second, the core concept. You cannot deny the authority under which you entered the property. And third, the exam importance. This is a high-priority topic, so pay special attention to the landmark cases and, of course, the exceptions. And that was our detailed breakdown of Section 116. I really hope you found this explainer helpful for your studies. For more legal content focused on judiciary, APO, and other law exams, make sure you stay connected with us here at Ganga Education. Now, this section is all about the estoppel of an acceptor, a bailee, and a licensee. For all of you preparing for your judiciary and APO exams, this is a really important one, so let's get right into it. So, here's our game plan for today. First, we'll break down the core principle of Section 123. Then, we'll zoom in on the three specific roles it talks about. After that, we'll look at some real-world examples and the exceptions, super important. We'll also touch upon some landmark cases and legal maxims, and then wrap it all up with a sharp focus on what you need to know for your exams. All right, let's start at the very beginning, the fundamental idea behind Section 123. You see, this section takes the general rule of estoppel and applies it to some very specific, very common commercial and contractual situations. Okay, that's the language straight from the BEAR Act. It can sound a little dense, right? So what does it actually mean? Let's put it in simple terms. It basically says that if you're in one of these specific roles, the law won't let you contradict a position that you've already accepted through your own actions. Here's the core idea, the absolute heart of it. If you've accepted a benefit from a legal relationship, You can't just turn around later and challenge the authority of the person who gave you that benefit. You can't have your cake and eat it too. It's as simple as that. So why should we care about this section? Well, it's absolutely crucial for business. It brings a sense of certainty to commercial deals. It's the foundation of trust in contracts. And, maybe most importantly, it stops people from being fraudulent or inconsistent, which is what keeps the wheels of commerce turning smoothly. Okay, so Section 123 specifically calls out 3 key players: the acceptor of a bill of exchange, the bailee, and the licensee. Let's take a closer look at each one. First up, the acceptor of a bill of exchange. Think about it. When you accept a bill, you're not just agreeing to pay, you're also implicitly saying, yes, I recognize the authority of the person who drew this bill. So you can't later try to get out of it by claiming the original drawer had no right to create it in the first place.
Second, we have the bailee. Bailment sounds like a fancy legal term, but it's something we do all the time, like giving your car to a mechanic. The person giving the car is the bailor, the mechanic is the bailee. Section 123 says that the mechanic can't later refuse to return the car by saying, hey, I don't think you had the authority to give it to me. He accepted the car from you, and that's that.
And our third role is the licensee. Now, this is very much like the rule for tenants. If someone gives you permission, a license, to use their property, you can't then stay on the property and argue that the person who gave you permission didn't actually have the authority to do so. You entered because of their authority, so you can't deny it. Okay, theory is one thing, but let's see how this stuff actually works in the real world. We'll look at some practical scenarios, and this is key for your exams. We'll explore the exceptions where this rule of estoppel doesn't apply. Let's go back to our car example. A gives his car to B for repairs. That's a classic bailment. A little while later, B decides he doesn't want to return the car. His excuse? He claims A wasn't the real owner to begin with. Well, what does Section 123 say? It says B is estopped. He is legally stopped from making that claim. But, and this is a huge but, there's a really important exception here. It's sometimes called the better title rule. So imagine B has A's car. Now, a third person, C, shows up with solid proof that they are the actual true owner. In that case, B is allowed to give the car to C. Now, if A gets angry and sues B, B has a solid defense. He can prove in court that C's claim to the car was stronger than A's. Now let's take an example with a bill of exchange. A draws a bill and B accepts it, promising to pay up. But when the due date comes, B refuses to pay up. His reason? He suddenly claims A never had the authority to draw the bill. Sorry, B, but you're estopped. You can't make that argument now. And just like before, there's a critical exception here too. Forgery. This is a game changer. Let's say A's signature on the bill was actually a fake, a forgery. B, not knowing this, accepts the bill. Later, B can absolutely deny that the bill was genuinely drawn by A. You see, accepting the bill doesn't stop you from proving that the entire document was fraudulent from the start. To truly get a handle on any legal rule, you have to look at what the courts have said about it. Landmark judgments and old legal maxims give us a deeper insight into the philosophy behind the law. When it comes to this topic, the case of Bank of England versus Vagliano Brothers is a must-know. This case really cemented the principle that when you accept a bill, you are bound by that acceptance. The act itself is an acknowledgement of the drawer's authority. It's a perfect illustration of this rule in action. The entire philosophy of Section 123 can actually be boiled down to this beautiful Latin maxim, nemo potest contra factum suum venire. It simply means no one can go against his own act. If your action said one thing yesterday, you can't come to court and say the opposite today. All right, let's shift gears and get down to brass tacks. What do you absolutely need to know to score marks on your judiciary and APO exams? Pay close attention because this part is crucial. Now, here is a very, very important point. Please remember this. Section 123 is a rule of evidence. It is not a penal provision. This means it works like a shield you can use for defense, not a sword you can use to attack someone or start a case. There's no punishment involved here at all. Comparison questions are a favorite for examiners, so let's quickly place Section 123 in context. You have Section 121 dealing with general estoppel, then Section 122 focuses more on property relationships like tenants, and then we have our section for today, Section 123, which carves out its own space for these specific commercial and contractual roles. So, for your exam prep, In the prelims, expect a direct hit. A question like, which section deals with the estoppel of a bailee? Easy marks. For the mains, they'll likely give you a problem-based question. For example, a whole scenario involving a bailee, a bailor, and a third party claiming a better title. Okay, time for a super fast recap. If you remember nothing else, burn these 3 things into your memory. 1. We're talking about Section 123 of the Indian Evidence Act. 2. The core idea is you can't deny authority after you've accepted a benefit. And 3. The 3 magic rules are acceptor, bailee, and licensee. So I'll leave you with a question to think about, something to take your understanding to the next level. How does this principle of estoppel in Section 123 really strike a balance between the rights of the original parties, the bailor and bailee, versus the rights of a true owner who might show up later? It's a fascinating question. For more in-depth legal content just like this, all focused on helping you ace your judiciary, APO, and other law exams, make sure you stay connected with us here at Ganga Education.
Thank you for watching this session. If you found this lecture useful, do like, share and subscribe to Ganga Education. Keep learning, keep growing and stay connected for more law lectures.